SJC-11950, Commonwealth versus Wright.
Good morning, Your Honors.
1 second, Mr. Mirsky. We can't hear you until the clock starts. Now we can hear you. All right, you may proceed.
Good morning, Your Honors. Attorney David Mirsky for Joseph Wright. I'd like to speak about the first issue in the brief, which is that the trial judge made a gross error by requiring defense counsel to turn over a essentially private expert report before trial started. And this had implications that were constitutional in the violations, but actually it was a misreading of the rules.
Well, but as I read the record, it seemed that there was a representation that there would be a mental health defense and that they would be calling the expert before he made that ruling.
But Your Honor, what I'm pointing to is Rule 14B2, large b, I through triple I.
Right.
And that section is a section that's where the turnover of documents occurs at a time after when there's an order of a court-ordered examination. So basically, it's been taken out of context. If you look at the end of the rule, at the end of following the 3 I's, you can see that it says at the time the report of the Commonwealth's examiner is disclosed to the parties, that's when the defendant is required to provide.
And it is a reference, it seems, isn't it, to the examiner's report, meaning the independent report? If an independent report was requested, is that it, by the Commonwealth?
The point is that this is a procedure that's intended to engage. If you also look at, I would point you to page 68 of the Commonwealth's appendix, the notes to the reporter's notes 2012 to this rule, the triple I, in order to avoid infringing on the defendant's privilege against self-incrimination, the defense expert's report is released to the prosecution at the same time that the defendant receives the report of the Commonwealth's expert. The point is that the Commonwealth's supposed to be engaged in trying to figure out the mental state of the defendant, not using the rules just to gain discovery of a private expert. And that's what was done in this case.
So you're saying that should never have been turned over?
Never. It's meant, if you look also, Your Honor, at B, in this rule, B 14, B2, capital B, it's the heading is examination. So
Certainly the rule anticipated that the usual course is defense counsel says, I intend to maintain a defense regarding mental state, generally criminal responsibility, sometimes diminished capacity, and Commonwealth says, Your Honor, we would like to retain our own expert, and then we go through this procedure, which is spoken of here.
yes.
In this case, defense counsel says, Your Honor, we plan to offer a defense with respect to the absence of intent. We have an expert that we expect to call with regard to that, and so, but the Commonwealth, for whatever reason, decides it's not going to retain its own expert. Your view is that the Commonwealth at trial, if Dr. Joss were to have testified, goes without any, must cross-examine him without his report, or do they get it after he testifies? What is your, what do you say the rule requires?
Well, he's a mental health expert. That's what he is. This is a
Okay.
mental health issue.
Right, I understand.
And the Commonwealth's job and the court and the rule provides for either the Commonwealth or the court on its own motion to order this examination. Their job, the court's job, is to make sure people, where there's issues of potential mental health problems, that they're not adjudicating somebody who doesn't belong there. That's
Right.
one job.
But
And
go to my question. What's the prosecutor supposed to do? Is he supposed to impeach Dr. Joss without?
no, he's supposed to do
report?
his own. He's supposed to file a motion for an examination. Or he doesn't get that material.
You're saying that unless the Commonwealth says we want to retain our own expert, they will then have to cross-examine the defense expert without the expert's report?
It's not their own expert. It's in the rules, Your Honor, that these rules are structured to protect, to treat a mental health discovery differently, and to protect the fact that a defendant is going to be giving statements and potentially losing his, or having his right against self-incrimination violated. And therefore, this structure is set up, this is supposed to be a mental health exercise,
Isn't the right
not a
side-
discovery of defendant's whole case exercise.
Well, it was meant, I mean, I was there. 2012, I was on the court when we enacted it. It was meant to be respectful of defendant's rights, but also meant to be respectful and fair to the need for the prosecutor to have a fair opportunity to be able to counter a defense expert. So that's what I'm trying to figure out, what you say now is required. So you're saying that unless the prosecution gets their own expert, or asks the court to appoint an expert, I guess more formally, that they have to cross-examine the defense expert without the defense expert's report?
I'm saying that the rules that we have now are structured around that, and the case Wright also are structured around a defendant being required to turn over those type of materials for when there's been an evaluation upon motion of the court or the Commonwealth for their expert to review, and it's a matter of mental health, and that's the way the rules are set up now.
Okay, and therefore, if the Commonwealth does not choose to retain its own expert, then what happens under the rules?
They don't get it. They don't get it under this rule, because this rule is for examination. For the examination is the court-ordered examination upon motion of counsel or the court.
Okay,
So they don't get it.
And why would we do that? I mean, the purpose of having the
You would do it because you want the Commonwealth to be looking into the mental health of people that come before the criminal bar, and that's what they should be doing. And the rules are not set up to take away a defendant's complete right to a defense, as occurred in this case. And that has to be wrong. And the rules may be...
I'm sorry. Why was your right to present a defense diminished? You declared your intent to do so. The Commonwealth then was on notice that it may have to defend against your claim that your client did not have the intent to commit the crime. They had the opportunity, but not the obligation, to retain their own expert. But I'm confused as to why they should be denied the opportunity to cross-examine.
They got everything that the council was thinking about, and all of that was just material that would have just, if it was something else outside of this rule, and council had made the same decision, which is what happened here. He decided, which I say erroneously, but not to use that expert. That wouldn't be known by the other side, but everyone knows it because the judge took the report and gave it to the other side, the prosecutor, before the beginning of the case. It can't be what this court wants.
So let's play this out for a moment. So
the defendant's going to put in a mental health defense, lack the capacity to formulate the intent, let's say. And you've got a situation where the expert's going to rely on statements the defendant made to the expert in preparing. So then the expert takes the stand. The expert can't say on direct examination what the defendant said. So if you don't have the report, if the prosecutor doesn't have the report, the prosecutor actually has absolutely no way to test the basis for the opinion.
Well, actually, that's not what we even had here, because counsel didn't know even what the report meant and misunderstood, and didn't know de Padova, and didn't know the significant things that were in there, and didn't use the expert.
I know, but what I'm
So instead, that's what I'm talking about. A defendant should have the right to investigate and use experts and see what they learn from them without having to produce it if they're not going to use it.
But can we just slow down for a moment, please? What I'm trying to say is I'm trying to think of the rule and the intent of the rule. If there's a mental health defense and the defendant's expert is relying on interviews with the defendant, and if the report doesn't get turned over to the Commonwealth, then what happens is the defense attorney can just ask for the opinion, not ask for the basis for the opinion, and the Commonwealth is going to have no way to probe the basis for the opinion because they don't have the report. Could that be
Yes,
what?
but I'm talking about, I agree, Your Honor, but what I'm saying is we're not to be concerned about that. What's really going on is they don't want to do an evaluation because they don't want to find anything out, because if they do, they'll have to turn that over and they'll find out that something's wrong with this defendant and it will affect the case.
But I might totally not understand what I thought I understood. But I thought if he wasn't going to use it, he wouldn't have to turn it over. He can't do
The judge
that?
in this case made him turn it
Right,
over at the beginning of the case.
Because he said he was going to offer the testimony of the expert. He said he was going to do that.
Right,
I
and then he
read that in
didn't.
the record.
Yes, that
Then
happened.
he didn't. He changed his mind.
Yeah, he did.
But the judge limited what the prosecutor could cross-examine him on
Well, the
to
limit.
avoid a Blaisdell issue,
He
right?
didn't limit it. If you look at the cross and you compare it to the pages of the defendant's statements to his counsel regarding the offense, it all comes directly from there. All the incriminating statements are taken out of there. They are read in as cross to be more incriminating. But what I'm saying, Your Honor, is the system should be that defendants first of all, it's called examination and it's keyed on examination.
Right, but it's under the
but
big
it
rule entitled discovery, pretrial discovery.
But what I'm saying is that if you're going to, the rules have other factors that set apart the mental health discovery and also work product, and that's given protection. And what I'm saying is that for these rules to work and for them to be fair to both sides, the Commonwealth should do an examination if they want that information, if they want it. If they want to get the information that defendant's expert has that was in that report, if they want to get that, then if they need to do their own examination and present their own version of what's going on with this person.
So let me ask you, this is a different question. What if the prosecution had decided to ask for an IME, and they had one, and the defendant also had his own expert that he was going to introduce? Would the Commonwealth then be allowed to have that report? Or
Yes, it says at the same time. That's what it says in the rule, and it also says, it says it in this part of the rule following the 3 I's. At the time the report of the Commonwealth's examiner is disclosed to the parties, and it says in the reporter's notes, it should happen at the same time. That the exchange should happen at the same time. Okay, because this situation that happened here, there are factors that council made errors, and I would like to go on to, there are other issues in the report. You know, I would, this is the issue, I believe, of this appeal. Okay, that we're talking about now. But I also would like the court to look at the fact that there was, in Dr. Joss's report, in his summary and conclusions, number 4, he makes a finding that's really an error. It violates the case Commonwealth versus DiPadova, because he finds substantial mental health problems with this person, but then says he cannot find mental disease because drugs were involved. And that's just an error, and that also affected what counsel did. Counsel obviously didn't know that, and I think that that something basic, substantive wrong happened here from the mental health sense.
But there was no there was no motion for new trial, correct, in this case?
No, Your Honor.
So we don't have
No,
any
and there's no
understanding as to why the prosecutor ultimately chose not to pursue a criminal responsibility defense.
Well, the reason there's no motion for new trial here, Your Honor, is because the issue that I'm talking about so overwhelms this case. When you're turning over a private report like that to the prosecution, you can't go forward without it. It affects what happened in the rest of the trial. It affects
Well,
what.
I mean, arguably you could potentially win on the first ground, but with regard to your claim that counsel was ineffective for failing to maintain a criminal responsibility defense, how can you possibly win here, where there's no motion for new trial and we do not know anything as to why the defense counsel ultimately chose not to present a criminal responsibility defense?
Well, it's clear from the record that he did not think it was available in that report. That's what he thought. He did not feel that that defense was available. That's what, and we have the evidence. The evidence, but we actually have something enough to do this on the on direct appeal, because the report of Dr. Joss is the evidence that would be used and to make those determinations. And the DiPadova error is right there at number 4, and that would there wouldn't be more evidence. The Commonwealth didn't do any examination, and they haven't presented anything, and that's also been addressed in the brief. Your Honor, I would also like to point out that in the evidence collection issue, the Commonwealth argued that there was no drug use, and their evidence collectors did not collect any drug evidence at all, and it was almost deliberate. If you look at their answers in their testimony, and at least under Olszewski, they should not have been allowed to make the argument that was made in closing, which made it sound like they were saying that there wasn't drug use. It was obvious there was drug use, and the report indicates it was serious drugs. Klonopin was one of them in the handfuls. So, and the other issue I'd like to address is the custodial interrogation in Canada. It was involuntary. The statements were involuntary. As counsel was offered twice and then not given, and then the defendant was immediately questioned after being offered counsel, which is not allowed, which is an involuntary type of interrogation, but also violates Mavrodakis and is a reason to apply the law in Massachusetts, even though it occurred in another jurisdiction.
Don't you have to deal with the problem that the War of 1812 failed in terms of our attempting to annex Canada to the United States?
We don't need to annex Canada, Your Honor, because the violation in a Miranda-type case is the admission of the evidence. And I would argue that admitting the evidence here, knowing the circumstance of it, it doesn't have to be, the argument against applying a Miranda-type rule in overseas is that you would argue that you can't apply the exclusionary rule, but the real violation is admitting the evidence, and that's what we do here, and we can control that here, Your Honor.
All right, thank you.
Thank you.
Ms. Slingerland, good morning.
Good morning, Your Honors. Marcia Slingerland for the Commonwealth. Let me just start by saying I think both defense counsel and myself agree that we should be under Rule 14b-2 because we're dealing with an issue of mental impairment. And that rule is, as this court knows, came from the Blaisdell situation, which is when there was a different issue there. There were two experts, and the defense in that case was objecting to have to submit himself to a court-ordered exam. And so Blaisdell laid out this whole procedure based on that premise, that could the defendant be forced to talk to a court-ordered exam? So you have the rule in place. And so what happened here, you don't have that predicate because, as Justice Gantz noted, the rule gives the opportunity for a court-ordered exam, but it doesn't require one to be given. The reporter's notes make clear that the regime for the timing of the disclosure of the reports is in the, it falls under B2B examination, and that is very clear. It does talk about the examiner's report is sealed and shall not be made available to the parties. In other words, anything that's privileged in there shall not be made available to the parties unless the judge determines there's a clear intent. Well, this is what applies here. Unless the defendant expresses the clear intent to raise as an issue his or her mental condition, and the judge is satisfied that either the defendant intends to testify or the expert will rely in whole or in part upon the defendant's statements. And that's what the judge did here, I'd suggest. During impanelment, he was trying to get a sense of what the case was about, and defense counsel specifically said he was seeking a murder 2 conviction based on diminished capacity, which was based on a combination of drugs and alcohol. And he told the judge there would be psychiatric testimony. There was a discussion during impanelment and before the case began about whether Dr. Joss's report could be turned over. And defense counsel, his premise was that it could not be returned over. However, the judge said, I don't believe that's the case law, and I'd suggest that he could find that given the nature of this defense, either the defendant was going to have to say, he's going to have to testify about drugs and alcohol, or the expert was going to have to testify based in whole and part or the defendant's statements. And not only had the defense counsel filed his notice earlier on, defendant's notice of expert witness, he's again, during impanelment saying, yes, this is going to be our defense. So the judge ordered at that point to have the report turned over. I have a footnote in my brief that it was turned over at some point during the middle of trial.
During impanelment or during trial?
It was during trial. There was something about, defense counsel objected again to having to provide it and said, I gave it a couple of days ago, and the date is on the transcript where he's saying that. So it was in the middle of trial.
But it was before defense counsel changed his mind?
Yes.
After opening statements?
Yes. I would also point out that during opening statement, there's a commitment by the defense where the judge could again find clear intent to offer, whatever the wording is, clear intent to raise as an issue his mental condition at the time of the crime, and he's going to have to either testify or an expert's going to have to testify. So the defendant makes that commitment during opening statement. He says the defendant does not deny that he killed his mother and his grandmother. And so the judge, even if he was a little early before in having the report turned over, which I'd suggest he wasn't, after opening, certainly he could have said, you know what, either the defendant's going to have to testify or the expert's going to have to testify based on the defendant's statements. So
What was the closing argument for the defense if he said he did it and they didn't offer an expert as to intent?
It was based primarily on the defendant's testimony, which was all about his drug use, his long-term drug use, and his drug use and alcohol use on the night of the question. And that was the gist of his argument, that he did not have the ability to premeditate or to act with extreme atrocity or cruelty.
If he puts Joss on the witness list, it means he's a witness.
Yes. And of course, he can change his mind, which he did here at the very end. He's entitled to do that. But I'd suggest the rule provides the manner for which reports involving mental health defenses to be, it's very carefully, a judge has to make a determination, and the judge did that here. And I'd suggest, even if he was incorrect, it was too early to turn over that report, which for the reasons I said it wasn't. By the time the defendant took the stand, certainly the prosecutor could have Joss's report at that point, because at that point he's waived his right to self-incrimination. He's taking the stand, he's opening up this issue, and he's putting himself on the stand. The prosecutor is certainly entitled to cross-examine him. To the defense point...
But there are two things that happen when one is the waiver of the cross-examination, but the other is it is still confidential as part of the attorney-client privilege up until the defense counsel decides, I'm going to call Dr. Joss. I mean, you can have your client speak with Dr. Joss, and then you can determine whether you're going to use it. If you don't use it, it's not disclosed.
But the judge acted properly.
No, I'm sorry. I mean, it's not. I mean, it's not disclosed until the defendant makes the statement of intent, which we speak of in Rule 14b.
Right.
That it is within the attorney-client privilege up until the attorney says, I actually intend to offer this defense and I intend to call that person as a witness. Then he becomes a witness at trial as opposed to a consultant to the attorney.
That's right. That's right. But you still can turn over the report. I think you referred to that in your dissent in Sleek Berdor. And so he changes. The nature of his role in the process changes. He is a witness.
But do you agree that if the defendant never said that he was going to call an expert as it relates to mental health, that the report would not have been turned over?
That's right. I think the defense has to have an intent to call this witness, and he had it. And he had it for a long time. And even after the defense, even after he decided, and he put on the record, I've decided not to call Dr. Joss for tactical reasons, Judge Whitehead says, I've seen Dr. Joss out there. He's available, and so he's made a decision, a voluntary choice not to call.
Do we also need to look at the psychiatric privilege, which is waived, again, when there's an intent to raise a mental health defense?
I think it is not so much a psychiatric privilege. I'd suggest it's an attorney-client privilege because the examiner, the doctor...
Is that, but,
yeah.
But isn't, on parallel grounds, isn't there also a psychiatric issue?
Like a psychotherapist privilege? I guess I would not believe that. There is the attorney-client privilege, I'd suggest, and certainly the privilege against self-incrimination, which is waived to some extent early on. But I guess I just didn't have a base of a case.
And that's because the purpose of that psychiatric interview is not for treatment.
Right. It was to advise the lawyer. What do we have here in terms of a mental health defense?
But if he were a treating physician, you would certainly have that issue.
Yes. Yes. In terms of the prosecutor's cross-examination here, there was ample evidence in this case for him to base his cross-examination on just that. There was blood everywhere. There was the victim's blood. It was the defendant's testimony gave the impression that he had been there, he was drinking with his mother, everything was fine, and then the next thing he knows, he wakes up and his grandmother is dead and bloodied in the floor below, and so is his mother. He doesn't talk about the specific details of the killings, which the prosecutor was able to elicit during cross-examination. But there was so much evidence, overwhelming evidence, certainly his cross-examination could have been guided by that. And the defendant had, again, waived his privileges, and he answered questions during cross-examination. I don't know if there are any further questions on this point.
Okay, thank you.
And I'm happy to go through the other issues, if there are some. The Canadian, I'll rely on the Fisher case, as the judge did, saying this is Canada, you don't have to give Miranda warnings.
Could still be not voluntary, even if there was no obligation to give Miranda warnings, though.
It could be. The judge specifically considered that and said, there was a caution given. He was told he didn't have to say anything. And in fact, when he gets to the point, they get to the point where the defendant says, "Do you want to know why I ran?" And the Canadian agent says, "You don't have to say anything here." And the agent says, "So why'd you run?" And then that's when he spills everything right there. He knew what, he was going, as he later said, he had to relieve himself, I believe, or he had to get it off his chest. I think he said that in his testimony. And even one of the agents said he seemed relieved after he'd spoken. But the judge's findings are supported by the record. There was a primary caution by the first agent. There was a secondary caution by the second agent who was interviewing or was just talking to the defendant about telling him why he was being arrested, which was for running the border. And he was trying to inform him about this so he could tell duty counsel why he was being held. He did not appear to be under the influence of drugs or alcohol at the time he was speaking with them. The agents were genuinely polite and relatively mild-mannered. He understood what was going on. There was no trickery, no deceit. So the judge's findings of voluntariness, I suggest, are supported by the record. I did not find any cases where the defendant had invoked his right to counsel and made this argument, except for an unpublished decision out of New Hampshire, State versus Mann. The defendant did invoke his right to counsel, and they said, no, there's no requirement that questioning cease. And if you look at what the agent said the right to counsel in Canada was you have a right to counsel, but not during questioning, which is what the Miranda right is in the States.
So when did he invoke his right to counsel here?
I'm sorry?
When did he invoke his right to counsel here?
In the United States.
No. When did Mr. Wright in Canada invoke his right to counsel?
At the motion to suppress, there was testimony that Officer Delisle, who was the first officer who picked him up after he was running around, she didn't testify at the motion to suppress, but one of the agents said, she told me that he wanted a lawyer. And so they're giving him they gave him a secondary caution and gave him his Vienna rights, and they're preparing to inform him. He's being charged with the Refugee Immigration Act, and so they take him into a room, and they're in the process of getting him duty counsel. They're telling him why he's being held, and that's when that exchange, the incriminating exchange, occurs.
Okay, thank you.
Thank you.
All right.